Thank you, Dan. Good morning, everyone. It is Wednesday, November 19th. We are the City of Topeka's Public Health and Safety Committee. Right now, we have only 2 of our 4 members present. Unless we get one more of them online, we will not be able to vote, but we will go ahead and have this meeting. It's being recorded, and also people are able to watch online. We're at a time where we particularly want input, and we don't want to slow that down. So with that, what we will do, even on, if the city attorney doesn't have heart failure over it, we'll go ahead and put items up for instance, approving the minutes for ratification to be ratified by the others on the committee when there's time. Thank you. All right, with that, I'll call the meeting to order. I am Karen Hiller. I am the elected council person for District 1, and I chair Public Health and Safety, as well as lead the Changing Our Culture of Property Maintenance initiative. With me is?
I am David Banks, and I represent District 4, Southeast Topeka.
Anybody else online yet, Dan? Okay, we will proceed. Next item of business is to approve the minutes of October 15th. Would entertain a motion to approve?
Motion to approve.
I will second it. Any comments, corrections? Councilman? Anybody else? Okay. Let's go ahead and vote our positions on that, and then we'll leave it to be ratified.
Okay.
All in favor, say aye.
Aye.
Opposed? All right, we're good. Third item is updates, and intentionally intended to be quite brief. Hopefully everyone here knows and was able to watch the presentation last evening at the full council meeting. We did what turned out to be, there were about 10 slides, thanks to our staff person, Nicole Stovall, and went through, and thanks to a presentation by John Chardine, our department head, who did a walk and talk through the printed materials that we have and where those are getting distributed. With that, we are not planning to repeat that today, but instead make reference to any questions or concerns or kudos, of course, that anybody who is here wants to share today. Included also as an attachment to that agenda yesterday, as well as an attachment to today's agenda, is the third quarter data report from 2025 that Ms. Stovall has put together. Again, lead staff at the city manager, assistant city manager have said that and because of some computer software changes, they really want us to get through moving the update to the International Property Maintenance Code, our city adopted code, by the end of December, so that it's in place for our software updates that will happen first quarter. And with that, rather than spending time on that data report this time, it's available for everyone. We would expect to be able to really focus on that. If there is, I'll jump ahead a little bit, but because we've actually been working on the property maintenance code all year long. Those of you who have been tracking, we handed it out as early as January to the council, and we've gone through some sessions here at the Public Health and Safety Committee, 2 months ago to focus on the standards, a month ago to focus on the fines and fees, to kind of progressively move ourselves forward. That IPMC is more than 60 pages long, so we wanted to take some time, and we did have some questions about it. So we're going to talk about it today. If, in fact, there is enough input via this meeting, as well as we invited last night input from the public by email or otherwise to let us know if they were eager to be part of a public session that was just focused on property maintenance, both the code as well as how we administer it, that we are open to doing that. So we'll go as far as we can today. But again, so the third quarter report that's listed here as the second update is available to you to look through. If you have questions directly, Nicole is here, is available. And again, we'll look at based on how this meeting goes, how those future meetings and therefore the agendas will drop. Hopefully that makes sense.
There was one correction that I did make that was on C3, number 13, which was how much abatement fine costs were waived per year and for what case type. MyGov does a really fun thing that sometimes it chooses to duplicate values and sometimes it chooses to not. So I had gone through, removed all of the duplicates from quarter 3, but quarter 1 and quarter 2 had duplicate numbers that were in there, which meant those total values were way higher than they should have been.
Okay.
So the version that was sent out for this morning has those corrected versions. They're much less, but if you had a previous version and saw that those were a lot higher, originally, that is the reason why that those changed.
Okay, so if somebody already looked at that either from yesterday or yesterday in advance of this meeting
Yes.
and has the wrong version, is the right version now posted yet?
Yes, we, I believe, sent out another corrected email.
Before I came over, so probably by now.
So if somebody wants the corrected version, they can go look where?
Are
At
those
the agenda for this committee or the yesterday's council meeting or both? The agenda for this committee meeting today has the corrected version now?
Yes.
Okay,
Correct.
thank you. Again, it was a little bit of a rush. We weren't sure we were going to be able to be on Tuesday, so kudos to everybody who pitched in to get that presentation together. Item number 4 on the agenda is to touch briefly on the new issues that were brought up on the 12th of November at the council meeting. We had a presentation that John did on condemnation and demolitions, and he did a really good job. The only feedback we've had on that was a suggestion from one of our council members that we consider changing the term condemnation because it's confusing when all we're doing is saying you can't occupy the house right now. So that's the only feedback we've had so far, worth considering. The second item that was on there was a proposed amendment. We've really been working on the fines and fees in terms of having it be fair. One of the things that we had discovered early on was that, and we'll go ahead and address these two briefly because I see that Kelly stepped up to address it now and we might as well. But the problem was that in order to treat people fairly at the court, then what had developed was a pattern that if a low-income homeowner needed extra time to do something, there was a sense that everyone had to be given extra time, yet there were responsible parties that either had vacant properties that just weren't keeping them secure or weren't keeping people off them, or rental properties that had the means and occupied tenants who were paying their rent, that giving them extra time didn't seem fair. And so we'd been looking for a way for some language that would, the attorney said we needed words that would separate those groups in order to accelerate where needed. So Kelly, do you want to follow up on that? We had a presentation with some language, and then it really didn't get much discussion, which was okay, but go ahead.
Yes, and we're looking for guidance as far as whether the council is interested in passing this kind of amendment. But it would be very beneficial, I think, to the prosecution of these code cases to be able to differentiate the owner-occupied versus non-owner-occupied, to be able to accelerate the pressure, I suppose, on those rental properties that are occupied to get into compliance faster, and to be able to allow owner-occupied that maybe have more minor violations, such as needing to paint in the winter, that we could give them more time and get them into compliance when they're able to do so, either financially or with the weather.
Using your example, however, just for counterpoint, would the same extension for having to paint in the middle of the winter be offered to a landlord as well?
I think it would have to be, just because for practicality.
Just checking,
yes,
because I think some of the language and the way it was presented at first was as if,
Yeah.
the city was just trying to squash landlords, yet correspondingly, there's been a lot of conversation about what a great job our mom and pop landlords do and how much we need them.
Absolutely.
And so to be careful as we talk about this.
So this takes away discretion for prosecution to dismiss a case just because it's complied with at that point, which is really the common practice, except, I mean, we take certain cases by case basis on the violations, and we look at different factors. But just across the board, we'd no longer be dismissing these types of cases that are non-owner occupied just because they are in compliance. But if they are unable to paint in the middle of winter, we're going to take that into consideration when it comes time to actually enter a conviction and look at the fine schedule for that. Did they paint as quickly as they could when it came to weather-related issues? That's going to matter. And it's just a practical approach to be able to take these dwellings on a case-by-case basis with a bit more of an urgency to get to compliance whenever we can, especially for tenants.
Okay. This issue is also under 5C in our discussion of IPMC, under fines and fees. But since she's up here and we're talking about it, let's visit about it a little bit more. There's a lot of technicalities that we learned along the way in terms of how to enforce this code. We, in year 2 maybe, put in this big section on progressive fees for repeat offenders, but then it turned out we weren't ever convicting anybody, and therefore we had no repeat offenders, even though everybody knew who they were. Well, a lot of people knew who a lot of them were anyway, put it that way. So does this, is that part of why we're looking at this to start? Let me throw in another challenge that we've had that we've talked about that we'll get to today too, is that in a technical sense, the way the code is and the computer software is set up right now, instead of somebody getting just one list of these various violations, they're each considered separately and as a separate violation and a separate notice even, based on the type of violation, whether it's sanitation, whether it's weeds, whether it's exterior housing, whether it's interior housing. This would allow it, and so one of the goals of the initiative was to have a single notice, which we still talked about whether the computer can generate it using kind of a report function. But technically, they'd be separate violations such that it would allow you to convict on one of them, but not necessarily the whole list. If somebody, let's say there was an extreme health and safety violation, but then it needed painting and the front steps needed to be fixed, maybe that's an emergency too, but depending on how bad they were. How does that work?
So this still allows for prosecutorial discretion as far as what is convicted. So if there are, say, 6 different violations, then we could still dismiss some of those counts for compliance and only have a conviction on the most egregious violation on the list. And so that's always a possibility, and that is also what we do when we do actually convict on these properties through discretion. Because we haven't often, but when it's been very egregious violations for non-owner occupied dwellings, we have required them to pay fines on those cases and not just dismiss just because they got into compliance. It was because the violations were so severe and weren't necessarily treated with urgency that they needed to be, because they knew about it months before it ever got to prosecution and it hadn't gotten cured. So this still allows for the discretion to look at the violations. And so, in other words, to answer your question, if it was a health and safety violation coupled with the needing to scrape and paint, I could dismiss that count on the paint and convict on the health and safety violation and put a fine to that.
Okay, thank you for that. Just in case it wasn't perfectly clear, this is Kelly Trussell. She is our Chief of Prosecution, and she also procedurally, and again, we kind of, when you look at our agenda, just divided it into standards, procedures, fines, and fees, because the procedures really make the difference. In this case, whereas years ago, we didn't have anybody in the city attorney's office that was responsible, and the cases just sat there. And then they tried, I don't know that we ever tried to divvy them out, but at this point, you're not only a chief prosecutor right now, but you've been with us since we started this initiative, and you've handled all the cases.
Yes.
Correct? So
Yes.
she's got the experience of how these have actually gone and working with the court and the judge.
Yes, and we've definitely made a lot of changes. The court as well has made a lot of changes in how we approach these cases, trying to get compliance faster, trying to find resources to help citizens who need those resources to help with those violations. It's a team effort, quite frankly, in trying to get the message out there that we're not trying to punish you, we're just trying to get these violations corrected so that everybody has a safe home.
Because even with those cases going over there, you're still talking with code, she still is talking with housing. There are people that have been approved through the grant program but haven't actually had any sort of work done to their home, like painting, things like that. And she'll check in with them, put them on that list and say, yep, we'll continue to monitor this until that gets done. So making sure that that job and then everything is completed and finished, but not necessarily going and just moving forward with a prosecution or anything like that because it's not done. They're waiting on a wait list. So taking all of those other things into consideration too, she's able to really funnel those different pieces with whether or not this needs to go forward because it's egregious and they're not complying, or whether these people are on a wait list, whether these people just don't have the funds. Is there any way that we can contact somebody with resources for that? She's kind of that do all, say all, but rather than just allowing the system to move people through, whether if it's volunteer compliance or not, being able to give her that power, I think would be the best thing for us, because then she can touch every single one of those cases and say what's best for this case in particular.
This idea was proposed, I don't know, in the spring, maybe. And at that point, it was targeted just at landlords and had some kind of flaming introductory language. At this point, though, because the proposal is simply to have some language, particularly referencing non-owner occupied properties, which encompasses, again, vacant structures, vacant lots, as well as occupied rentals, in order to, as needed, deal with that. And it's actually just an added sentence or two to one of the sections in the code. Is there any reason for us to do a separate ordinance, in your view, versus just consider whether to include these two lines in the proposed updates to the property maintenance code?
I think these two lines that we are adding to the current ordinance and changing some of that language, I think we struck a few words out of it and then added the language. I think it's appropriate where it is because it goes along with the council's intentions of treating these properties differently because we want to make sure that tenants have safe habitats or houses, as well as also addressing these vacant structures that are not being secured, that are, being entered.
Constantly.
There's vandalism, there's problems with fires, there's all kinds of issues. And so addressing those properties separately and differently than the owner occupied dwellings, that is, I think it's good placement in this ordinance to go along with in the preamble, what the intentions are of council in order to differentiate these properties.
Okay, I just didn't see any reason to run concurrent things if this is exactly two lines that fit in to what we're doing right now.
I think, and I think it's also better for the public to be able to find it in one location so that you can see exactly, for readability purposes, understanding the law, understanding what's required, and how these cases are going to be treated. Making multiple ordinances out of it only complicates things, I believe.
I thought so, and because the original version was targeted, it had some fairly flaming language about landlords in it, and it didn't seem like there was any point in asking anybody to rewrite it at this point.
No.
Either. So just wanted to check. Okay. Well, with that, thank you so much. The reason I put it ahead was to see whether we wanted to consider this one soon or wait until after we'd done the code. And so if the sense from staff is that we could consider it as just part of the IPMC moving forward, then that would accommodate having raised that issue a week ago. We'll just go ahead and include it unless there's any objection. Okay.
I have to get it approved by legal first before we consider it. I
Well,
mean, she's just one part of the legal team. I got Matt Mullen on the other side.
Yeah, well, what we have is the wording that Matt produced, and so unless there's, we can double check it. I've been a little uncomfortable with people wanting us to vote this out of this committee today when there's so much interest and input and catch up, but yes. Well, fair enough
Yeah.
to double check that, because there were some questions about, I'd had a question about the very last line that he added.
On the fees, or which, do you remember?
The issue of the inspection fees.
Yes.
Because we'd been talking about that originally as something much broader than just this, so.
So the inspection fee language is something that Matt and I actually worked on together.
Okay.
And we, in a way, we kind of looked toward the cruelty statute or ordinance, and how to get to that language as far as assessing an inspection fee. I like the way that it's drafted because it requires an inspection fee upon conviction. It doesn't say how many inspection fees have to be required, and so if a non-owner occupied case was very quickly complied with, I think it's fair to do one inspection fee, because there are resources that go out from property maintenance that go into these inspections. And if we have a situation where we've got interior inspections that are being set up over and over again with property maintenance inspectors, and then the owner doesn't show up, and so they have to go out multiple times, that gives us discretion on how many fees are we talking about. But I do think it's fair to impose one inspection fee. I don't like the idea of just tallying every time it was inspected and on its face saying that's how many fees that we're going to have. Because a lot of times those inspections are triggered because they're on the docket and they have to go out in order to report back to prosecution on what kind of progress is being made. I don't think that's very fair to the owners, no matter what kind of owner they are. So the language that's added there, I think, is sufficient to require an inspection fee, but it gives wiggle room as far as being able to look on a case-by-case basis of how many fees should be assessed.
Well, and that came out of discussion in this body about the issue of, and also in with the staff team at the just COCPM work, that when should those successive, the code has provided for fees for if there was follow-ups required, yet we weren't charging any of those either. And the thought was, okay, we don't want to charge them to everybody on the first visit. Okay, the first visit should just be a first visit. And it turns out to be a courtesy inspection or a write-up, whatever. And the first follow-up to see if you've fixed it, fair enough. Okay, maybe the city covers that as part of the program. But then it had to do with the extra times, and then the conversation we'd been having was everybody. And so the question I had that we sent back to Matt was, okay, but what about these owner-occupied ones that have junk in their yard or that are having their weeds, go all season long, they don't mow at all. Maybe we only mow it twice, but darn it, it was over 12 inches for 2/3 of the summer. By limiting the re-inspection fees to the non-owner group or the non-owner occupied group.
I think it's to everyone.
But it
just
doesn't
has
say that.
language for the non-owner occupied, but that whole entire list is anybody that goes over for docket.
Well, that's what I wanted to make sure.
Because I think there's that tiered system, but then inspections would also, I think, apply to anybody then that's convicted.
As it's written right now, it does, inspection fees do actually go only to the non-owner occupied property. But again, that's on the prosecution side, it's not on the administrative side.
Yeah, we would have one typically inspection, then we would have a follow-up inspection, and then potentially if there were some sort of extension that were given, then maybe an additional follow-up. But at that point, we would forward that on over to docket, and then that's where a majority of those re-inspections have to come, because every single time it goes to docket and it's scheduled, that inspector has to go out, take pictures beforehand, so that she has current, up-to-date information on where that case is.
Well, we're getting kind of deep into the fines and fees and procedures thing at this point, but part of our goal with changing our culture of property maintenance was to minimize the cost to taxpayers of the city. And when it goes to the docket, you're talking about paying lawyers and judges to handle all this. And so minimizing the need all the way back to the beginning to have an inspection at all, because everybody was just mowing their yard and keeping their junk put away and painting their house. But to not have a fee ever be assessed unless it's gone to court means
I mean, we
that just
already have our,
administratively-
we have our administrative fees just
And they
for,
can double.
going, and those can go out based on whether if it's a single offense or if it's a repeat offender. And then our 140 and 175 based on general violation, vegetation or vehicle.
Okay.
So we have fees that's on our side that can be assessed immediately from the very beginning. It was just
And
more
those are
so,
more, if you will, just for folks that are listening to, on the civil side, those are
Yes.
administrative fees. When it goes to court, then we're talking about criminal offenses, and so
Yeah.
it's a different, kind
yeah,
of two
our
different
fees are
legal
separate.
buckets.
We would assess all of our fees, we track all of ours. She assesses all of her own fees and they track all of theirs.
And those types of cases that you're talking about on the weeds and sanitation, and on those types of violations, those, only really the habitual violators or extreme cases are the ones that are referred over for prosecution as well. Pretty typically, it's handled on the administrative side. But we do have those cases on the criminal docket, and those are usually for cases that have been repeat offenders. Or not addressing, and it's caused, huge amounts of sanitation issues and things like that.
Garbage, for instance.
Yes, and those again are taken into discretion on what is the violation, what's the background on that violation, what's the facts of that case. There's been, as you know, some major sanitation cases in the city in the last year that we have required fines. Mm-hmm. And it's because of the facts of those cases.
And they typically could have been dismissed because they did eventually comply.
Yes.
They had voluntary compliance, but at that point, it was such an issue that we went ahead with that. Whereas this, it would have immediately not been dismissed. You would have evaluated it from the very beginning.
Yes, that's correct.
Appreciate this discussion. Again, for the folks who have taken the time to join us, which I'll speak for everybody, appreciate so much. This is, we joke about this a little bit, down in the weeds on how the property maintenance gets done. And it is technical and it's complex. I think for those of us that are trying to evaluate the words as well as the actions and how it's going to go, how it feels, whether it seems fair, how the results go, is to step back. We need to understand these details and talk about them if there's any way we can improve the system. But the net would be, okay, has it seemed kind of fair so far? And if not, what were the bugs? And does this conversation and listening to this staff talk about how they've looked at it give us enough confidence that we can update that ordinance with whatever there are suggestions in there, and then whatever would come out of these discussions, such that we could feel reasonably confident that there's still plenty of time for input back and forth, but we've got a base that could work. So it's kind of where we're at today. Let's thank you for stepping up immediately in this discussion on this. I think it's hopefully it's helped to frame the whole thing of the fines and fees for everybody as we move forward in the agenda. The second item, or the third item that came up at the meeting on the 12th was the issue of rental registration, which had come in from outside this committee, had been talked about before. Because it's separate from the code itself, and we need to really focus on that as chair, I don't think we've got time to kind of ride out to the side and address that as well right now. But I also would like everybody to consider, we spent the time to get that presentation done on the 18th because it did appear that a lot of the things that people thought that such an ordinance could do, either we are already doing or able to do, or not possible. And so what the net that came back to me after that meeting was, they need to explain exactly what they think we're missing. If we want to, the advocates for that, if we want to move forward. I think we were hopeful that the explanations on last evening's agenda of the ability to get information about renters versus homeownership, about getting owners, the fact that was a little misunderstood, that no matter what we do, it's still not going to get us entry without permission of an occupant unless there's enough reason that we would be able to get a warrant, which we can do now. Also, people were not particularly aware of the outreach efforts that we have, that we're covering all multifamily units. So hopefully people will take that under advisement and look. If there is enough interest, we can certainly address that at a future time, but was looking at prioritizing the IPMC right now so we can get it done. Hopefully that's okay with folks. Any questions on anything that we just talked up from item 4? Otherwise, we will go into discussion of item number 5, the property maintenance code itself, which I will invite comments from anybody that's here, as well as the committee and staff to discuss. Anything on item number 4? Okay.
Yes, I have.
Okay.
You want me to come up here?
Absolutely. Please say who you are and maybe give us a peek at whether you're an advocate, a tenant, or a landlord.
Morning, everyone. My name is Matt Cobb. My wife and I own several rental properties in Topeka. I've got some concerns with at least the draft that I saw, the red line draft of these changes that are you guys are looking at. I think that case law is pretty clear that there's a separation of powers, that the legislature writes the laws, the executive branch enforces them. So does the city attorney's office think that there's no conflict in separation of powers to draft an ordinance that removes their discretion on whether or not to dismiss a case?
So, no, I don't think there's a conflict. The city attorney's office, part of their responsibilities is to give guidance on the legalities of these ordinance changes. It's ultimately up to the city council to pass those changes. And that's a vote. That's where we are separating those powers. And the discretion is not that I cannot dismiss a case, it's that we don't dismiss just because it's been complied with. I can still dismiss a case if there's various other reasons to do so.
So if I receive a code violation notice because my renter let the grass get too tall and then they mow it, well, the ordinance says it shall not be dismissed solely because it was abated. So what other criteria would you use to decide whether or not to dismiss it or drag me into a hearing? Well,
in that situation, that again would be on the administrative side, not the criminal side. And so this discretion issue on this ordinance change goes to the criminal side of the fence, not the administrative side. So if the city comes in and mows the grass that the tenant let grow, then that's going to be on the administrative side and not the criminal side.
So that
Okay.
process is that we would evaluate, write up that violation, go if there was voluntary compliance, then we may or may not have any fines assessed on the administrative side. If we go evaluate it's not been mowed, then we would forward that over to her. During that time between us forwarding that over to her and her actually assigning and having it listed on docket in that day, there could be in that time frame that you comply. Normally, we would dismiss that then. So during that time of it actually getting to her versus when it actually is scheduled for docket, sometime in that period is when there's compliance where we are evaluating that it wouldn't be voluntary, that we would just dismiss that.
And that's the practice now, and that would be the practice in the future as well, where in the time between the referral over to my office for criminal charging, and even if I already charged it but didn't have that knowledge yet that it had already been cured, the dismissal request would be because it was in compliance prior to me actually charging it, and now I have that knowledge. That's different than dismissing because it was complied with after it was charged.
Well, I understand, and then up here it takes a lengthy explanation, but the ordinance is pretty clear that the prosecutor shall not dismiss solely for abatement. And I think Kansas case law is pretty clear in State v. Williamson and State v. Pruitt that prosecutors have to maintain discretion. They can initiate, decline, amend, or dismiss charges at their sole discretion, not because the legislature drafted an ordinance that says they can't dismiss it, or even puts language in restricting them in any way whatsoever. So I would just ask that the city attorney's office, you said you give guidance to the city council, I would ask to make sure if that guidance hadn't been given and that case law hasn't been researched, that you do so.
Well, I would still, ethically speaking, I do have to have discretion in criminal proceedings. There are lots of various reasons that I would have to ethically look at a case and have to dismiss or want to dismiss based on those facts. If there was an evidence issue, that would be a reason. Even if it was complied with, I'm not dismissing because it was complied with, but I'm dismissing because the evidence, there was a lack of evidence to prove the case. If there's an ownership change, there's all kinds of reasons that I would use my discretion and still have all of that discretion. But there's nothing to stop council from passing an ordinance that says you're not going to dismiss cases just because it was abated.
Well, what would stop it would be the city attorney's office guidance to the council to tell them it's not a good idea and it could violate Kansas state law. And I'm glad that you brought up the ethical obligations because Kansas rules of professional conduct for prosecutors obligates them to pursue justice rather than just mechanically file every single charge. I think that's the language. So any ordinance that restricts your discretion in any way, I think violates that. And I think it could be challenged in court, and I think plaintiff would be successful. The other thing is, I think that this pressure that you spoke about putting on landlords, it's a little disheartening to hear because of the time and money and effort that my wife and I have invested into this community. And then I know everyone comes from different perspectives and have different jobs to do. But when you talk about pressuring landlords, that's me. That's my wife and I. You may mean someone else who's creating problems in the community, but you're talking about non-owner occupied dwellings, which are all of mine. So you're talking about me and my business, and then you're talking about pressuring landlords. That's me. And I would just like for everyone to maybe rethink their word choice instead of lump all landlords together when there might be 2 or 3 that are creating all these problems and causing all these discussions and looking at the ordinances. But I think that this also creates a 2-tiered justice system where if you have a house that's not occupied by an owner, then this is how we handle that. If it is owner occupied, we handle it differently. It's not equal application of the law, and I think once again, it could be challenged in court. So I would also ask that the city attorney's office educate the city council before they vote on this to think about that as well, that you are in fact creating a 2-tiered justice system that's based strictly on ownership. I think it raises legitimate concerns of equal protection and selective enforcement.
If I can try and help a little bit with my understanding of where this came from, was that where it came from was the reverse. Was that because we had to treat everybody the same, then the egregious offenders weren't getting penalized. They were just getting let off like everybody else. And so and help me out with this, but that to be able to begin to separate that, to give permission where it was warranted, where you had an intentional or egregiously, this might not be the right words, neglectful property owner who was not taking responsibility for things that were clearly a problem that they knew about. Was that the city was concerned that we weren't making the progress we needed to overall in the city because those folks were getting let off the hook because everybody else was getting let off the hook. And there needed to be some language that the lawyers felt was adequate to allow them to separate out and actually put those repeat offender charges against those who really were egregious and neglectful, because the routine was to dismiss charges if people complied, and then at which point they were not an offender because they weren't convicted, and therefore we weren't assessing the multiple penalties against anyone. And those folks were continuing to be irresponsible and causing harm to neighbors, tenants, whoever, an expense to taxpayers. So if
Yes. And I would just add to that this is when it reaches the level of criminal charging. Most good landlords, like yourself, if you were to get a notice from the property maintenance that you had a violation, you would fix it.
Well, my tenant would fix it. And I think that's actually, there could be a disconnect in the understanding of how these things work on our end. If I get a notice in the mail, I immediately notify my renter that
absolutely.
I got the notice, the grass is too tall. It says in the lease, you've got to keep it within code. And I sent them pictures of the notice, and here's the deadline to have it fixed. Whether they fix it or not is up to them. I understand that I ultimately am I'm the middleman between it, but I've had 3 code violation letters in 15 years, and they were all caused by the tenant. There were tenants, and they were also violations of the lease. So I don't understand why enacting an ordinance that removes the prosecutor's discretion to dismiss after abatement and dragging me into court because my renter violated the lease, which is actually something I can't even evict my renter on. They could do it over and over and over, and I can't evict them for it. So I had one renter that I actually feel bad for him because we got fined because he got the letter for tall grass. He mowed it 8 times from July till whenever, and then I get the fine in the mail. And it's because there were some weeds along the alley that weren't actually specifically addressed in the original letter. And I told him, well, the law's the law. I guess you got to think street to alleyway. So he got charged for it. I think there's this misunderstanding in the community that we're going to pressure these landlords to comply when actually it's, at least in my experience, you're hurting the renters. But this pressure that you're putting on investment properties and non-owner occupied properties just in turn ends up getting passed on to the renter. It's not greedy landlords that are going to foot the bill for all of this. Those get transferred, my lease even says, those charges get transferred to the renter. So, and I've had to do it one time. But this aggressive enforcement, because you see on the appraiser's website that it's owned by an LLC, it doesn't actually hurt me. It might very short term, but it gets passed on to the renter. It causes them to receive fines, it causes rent to go up. And if I'm going to get dragged into court because my renter didn't mow the yard and the prosecutor didn't dismiss after it was mowed, that could be an additional fee. So I may have to go through and amend all of my leases to cover myself if I get dragged into court because the prosecutor's discretion to dismiss was removed.
And so I think, again, though, the weeds cases and things like that are really on the administrative side. You're not going to criminal court for that.
I understand what you're saying, but that's not what the ordinance says.
Because this ordinance goes to the criminal cases. It doesn't
Right.
go to the administrative cases. That's a separate issue, separate ordinance. This particular ordinance change goes only to the criminal cases that actually get charged in municipal court. And that's different than having to mow the grass. Now, if it did get referred to my office, I'm just going to use your example, and you show me that in the lease, it's the tenant's responsibility to do that, I can still use my discretion to dismiss that case. That's a defense to the actual violation.
I know, that would be my
But
exhibit
if we
A.
can, let me, you raised some really good issues, and I'm really glad we're having this discussion. I go way back to when the decision was made to only send those letters to the landlord, because it used to be that, I mean, this is way years ago at this point, but that if it seemed like it was the tenant's responsibility, it got sent to the tenant. And when the IPMC was passed in 2015, I think that's when the change was made. And the wisdom there was, if you might disagree, was that relationship of who's responsible for the property is between that landlord and the tenant, and the city doesn't need to get in the middle of that. You know, they can send the letter to the landlord and send a CC to the tenant, which generally happens when it's an occupied rental, right?
Any,
So the tenant gets it at the same time.
yeah, any address change
So
that we
that-
have listed, we will send it to both.
So that the tenant's on notice, but because the landlord is the owner of the property and therefore responsible for code compliance, they leaned on it that way. And so that's why. And it seems to have worked okay. I mean, even in your situation, you took care of whatever that relationship was with the tenant. You know whether you've been on them or whether you even knew about it or whatever. I want to switch to another point that you made, though, and check with John, because I'm aware of complaints in the past, not recently, but in the not too distant past, about people who went and mowed and then still got written up for stuff that was around the light pole on the corner or on the alley and so on. John, what's the status of what instructions and your inspectors have right now about in advising people what they mean for mowing, and if there are stray weeds around the borders or the corners of the property, are those still getting pursued like the ones he described?
Yeah, as a matter of fact, we tell the occupants that all vegetation must be cut below 12 inches, right? From alleyway to the front yard to the street. I made a policy change about 30 days ago. Before we take any legal action, we are required to call you now to let you know or to ask, because we have to investigate, right? So we're trying to figure out why the property's in violation or why it's continuously in violation. So if I call you, if my inspectors call you, that's what we're looking for. Like, hey, can we help you in any way? There's an issue, it's ongoing, we don't want to charge you, we certainly don't want to bring you to court, because I don't want to say it's a waste of time, but I would rather you spend the time fixing it than in court, right? So we're trying to figure out what's going on, what can we do to help, what's the core of the problem. If we can figure all that out, chances are I can keep everybody out of court, because we either have resources or I can guide you. For the landlords and the property owners and that have more than one property, certainly this has been working, because if you look at our initial inspections compared to our secondary inspections follow-up, they're equal. And that's what you want. You want a first inspection, second inspection, and a case closed. You don't want a drag on for multiple inspections. So yeah, to answer your question, we do require it from
Okay.
alleyway to the front of the street.
But you'll let people know, not just nail them later.
Right, no,
Okay.
that was not the intention at all.
Well, even something in that was in July. If the letter just said the weeds along the alley, that would have cleared everything up. It wouldn't even required a phone call, but he was charged.
Well,
So-
and that kind of input is helpful. John has continually worked on the letters.
Yeah.
You know, if there's some clarification that we can put in the boilerplate, or that staff can put in the boilerplate letters, that helps people understand from the get-go. Third point from what you made, just to check with Kelly, if, for instance, you weren't you, and you had this problem, you got written up for you and with a CC to the tenant on just the grass being too tall, maybe it was just 15 inches tall and they just aren't mowing as promptly as they should, or their kids' toys are out there and they didn't feel like picking them up, and so they just didn't get it done. But on the other hand, maybe you're somebody who's going to get toe to toe with the tenant on that and say, no, it's up to you. I'm not mowing it, and you're going to have to pay whatever happens. And so it gets taller and taller and taller. It never gets mowed. It's between you and your tenant, but it never gets mowed. It gets to the point where the neighbors are starting to call code and say there's snakes out there, there's rodents. Can't you make this guy get this property cut one way or another? We don't care what you do, but this is impacting us as neighbors as well, which we've had. You know, on the council, we get the complaints, right? The things that don't work. At that point, a case like that could accelerate from being just that administrative mowing and abatement case. You know, often the city gets in and mows, but that's a cost to the taxpayers as well. All that admin time and so on that we're trying to get rid of. But if somehow we didn't abate it for you and charge you for it, it could accelerate to the criminal thing if somebody was just digging in, right?
That's correct. I mean,
That's happened more, in my experience, on vacant lots
Yeah.
than on an occupied rental.
and
But
really at that point, it's a health and safety issue because the neighboring properties are suffering from that growth. And so, yes, those are the types of cases that would come over to prosecution where it's just gotten out of control. Or
just wanted to go ahead and do that link because it could happen.
it could happen.
Unlikely,
And
but-
it has, but really, it's pretty rare that we get weeds cases over in prosecution. It's only the most extreme cases.
Just wanted to follow through on that. Because
Thank you. Just to recap, I think that any language in the ordinance that removes or suggests that the prosecutor won't have discretion to dismiss a case, I think it violates clear Kansas case law. Even if you can explain that there are some other avenues where you do still retain some discretion in other circumstances, I think it's a clear violation of Kansas law. I also think it can violate the ethical obligations under 3.8, and I think that unequal enforcement of how we treat non-owner occupied properties versus owner occupied properties can violate equal protections and equal applications under the law and selective enforcement. So I would just ask that the city's attorney's office research those items and make sure they educate the city council.
We will certainly do
Okay,
that.
thank you.
Thank you for that. And just from my experience and how this has gone all this time, the flip of that was that got to that point because they were really wanting to protect the low moderate income folks that didn't have the skills and or the means to take care of what needed to be done right away. And so it was really not driven, at least in my observation and experience, by wanting to nail certain people, but instead to be able to proceed and still protect, to create that ability to protect those LMI owners, right or
Well,
wrong.
And I understand, I think also there's also an intent of the law versus the written law. And I think the way the law is written could actually be in conflict with the intent of the law, which I think is something else that could come up if any of this wording was ever challenged.
If there are any
So-
suggestions you have on how we might write that a little bit better, we're open to see them.
Well, I've made at least a couple suggestions that,
Understood. But, like you said, the words, how you
Right.
put those words together. They've
Well-
worked really hard on it, but that's what we're here for.
I feel like if we talk for 10 minutes, we're all on the same page and we're all on the same team, but the law's not written that way. But then in meetings, separate from the way the ordinance is written, then everyone starts to paint the picture of what the intent of the law was supposed to be, but that's not the way that it's written.
Appreciate it.
All right, Thank you.
We'll definitely take a look at it again.
Thanks.
We're not looking to do anything illegal by any means, so
Absolutely.
we will certainly research anything that.
Or to hurt anybody.
No. Yeah, it's not the intention.
Most folks don't like dealing with code compliance, right?
That's right.
So here we are.
Next.
Pat?
My jaw dropped, Karen. You really believe low-income people don't have the skills to mow grass?
We're not just talking about mowing.
But that would include it in that. Yeah, a simple things to correct out of that thing is change one word, and that's strict liability. Most people don't know what strict liability is. You strike that word, and all of a sudden the tenant's responsible for that nuisance things they put in the yard. They're responsible for mowing the grass. They're responsible for that couch on the front porch. Strict liability means it doesn't matter who caused the problem. The owner of the land is responsible for it. The reason we had even put that in there is years ago, we're talking about 10, 20 years ago, we talked about this problem and how to make tenants responsible, things like this. And their response, City of Topeka's response is, well, we want to go after the landlords. If we find the tenants don't pay their bills, the landlords do. And then we can put a lien against their property if they don't pay the bill. Wrong philosophy completely. You should make individuals responsible. Landlords aren't responsible for raising your children who were raised improperly, which I heard that the other night. You need to hold tenants responsible. Right now, they're not. Right now, we don't even require, which previously it was, to give the landlord a 14, 30-day notice of a problem before the code call. We actually encourage code to be called first. Come on, what are we doing? Single family, two family, and three family homes, typically from the IRS records, they don't make money. They typically lose money. And you can find that out not easily. It's considered a trade secret, but it is part of IRS records. That's how they figure out. They have records on every business. And they look at how much money you're losing, how much money you're making, and you may raise a flag. That's it. Landlords, small people, we're optimists. We think property is going to increase in value, and that's where we're going to make our money. And you know what? Most of us are wrong. I've seen my friends retire, and they're selling the property for the same amount of money they bought it for 30 years prior. And then I have to point out, no, you're not. You've lost money. Take inflation into effect now. Then all of a sudden, it's the only money they make is the difference from what it rent the house for and what it costs them to maintain it. Right now, national average for a two-bedroom house is $1,800 a month. Kansas is on the low end. Kansas is at $1,243 for a two-bedroom house. Topeka is even lower than that. We're only $1,100, and that's according to Zillow. You keep on pushing these codes, they're going to go up and up and up, and we'll be at the national average of $1,800. Let's look at the increases we've already made, because we're already being punished for this, and that. Nonsense. Now we have Kansas Legal Services. We have hired them paying approximately $80,000 a year to help tenants with evictions. And we're in the second year of the contract, or potentially 3-year contract. It's increased the time to get somebody out from 1 month to 2 months now. And I don't see any results of the ultimate people who are now removed from that property, either by settlements or by the actual eviction. It's just slowing the process down. Next time we have this 3rd-year contract coming up, you ask them, let's see what it was 5 years ago. How many people have been displaced from there to now? Our population has not grown. It's actually shrunk a little bit, so the numbers should be accurate. I've gone up against them twice, and they've lost twice. A pro se, it's embarrassing to an attorney when they lose against a pro se. That should not happen. Now, to point something out, yes, housing can have problems, and we have enough systems in place to already take care of it. Last council meeting, or council before last, I handed out this piece of paper which did not get to explain it. I'll give it to the 2 council members present here.
I think we got it.
Yeah, but no explanation.
Okay.
What that is a proclamation by the former mayor, James McClinton. The Topeka Housing Authority had turned their way around so much They needed a pat on the back, and this was it. In the 90s, they were absolutely horrible. I'm surprised the FBI did not rate them. For their own property, they were rated at 56.5. For Section 8 property, 41. That's out of 100. That's lower than Timberley scored. Now, Timberley, Timberley scored 0 out of 100. That's politics. That's all that was there. You can't tell me that. But projects have and do go bankrupt. Example, Bentwood Apartments. Those apartments, which they probably changed names, behind East Lawn Shopping Center back there, they've gone bankrupt twice. We've got the apartments behind Walmart on Wanamaker, those nice white ones. They were low-income housing. They went bankrupt. Timberley is now in receivership. Timberley is a corporate word for bankruptcy. We have another units that were California and Highway 70. They're big, they're low income. They've gone bankrupt before. Now we're looking at, and you don't know it hasn't happened yet, but I think Pioneer Motive is headed towards bankruptcy. They've been having problems of getting things done. Matter of fact, the elevator, I believe, broke in that building, and they didn't have money to repair it. And so the city, I am very pleased, did the right thing, in which they don't often do that, and they paid to get those elevators repaired. It is going against the property taxes, though, and so it does need to be paid back. But we rarely step in and help when there's huge maintenance problems on this. We should back off a lot of these things. A lot of times also in the court, unfortunately, happened to me. I testified state legislature last year on a big issue. The city wanted to get inspections inside a house. You know what? All of a sudden, I end up in municipal court on 3 charges or 3 issues that should have gone away. They did not. They came back off. And they were like, what the heck's going on here? And one of them had to do with numbers on a house. All of a sudden, well, evidence revealed, oh, he did take care of this. Why are we here now? Well, we'll dismiss it. Another one had to do with, well, it's to take a half hour to explain anything. But all of them ended up getting dismissed and the fees waived. Went in front of the judge in the last one, and the judge has now considered me a habitual offender. What garbage? Because I've got political pushback for talking to the state legislature? Bad, bad, bad. Things happen, gentlemen. We have enough things in place to do it. We shouldn't be so nitpicky that it should be only about safety and health, not increasing property values. And that's what we have said in many meetings that this is about. If it doesn't affect safety and health, we shouldn't be looking at it. How does plastic on a window to keep the cold air out, which is passed out for free from community action, how is that a criminal offense when you have it up on the summertime and then take it off? Well, it was. I got written up for that. How is having tar on a roof, the metal drip edge, that thing, you accidentally getting tar over that? How is that a criminal offense? Well, it is. Got written up for that. How does that affect safety and health? We need to back off hugely if it's really about safety and health, because that is the only thing the state legislature has given us authority to do. Now, true, we get away with a lot of things in our codes. Why do we get away with it? Because our population is relatively undereducated and poor. They can't afford attorneys.
Thank you for this. If I can stop you and we can segue into our further discussion on the property maintenance code, the first item under there was the standards. And I'm really eager for us you've mentioned a couple, plastic on windows, a tar drip off the roof right now. We want to make sure that if there are any standards, that aside from the enforcement process and the code and all that, fundamentally this code is to enforce standards that we've identified in the code. The IPMC is very, very long and detailed. We've gone back and forth about that. I've asked for people to talk about it in prior meetings about whether the earlier version that we used to have that's more general and easier to read than this detailed one was a preference. What has moved along because the attorneys and the staff like all the detail in the international code format is to move that forward. But it very much, if we can, and so Pat, if you have some other examples before you sit down, otherwise let others, if they have them, identify any standards that you think are in that code that are too specific, not needed, whatever, so that we make sure we catch those, because we are the ones that write that policy.
Other cities under the same code, in painting, they've gone with 20%, not zero. So you've got something size of a postage stamp coming off in paint. That's a criminal
20%?
offense. 20%.
Okay.
Other cities have looked at this and done several things. Number one, they don't like their code people using binoculars, using cameras, normal vision only. You don't use zoom, you don't use ladders to look over fence, you don't stand on top of pickup trucks to see that. They also were in the habit too of looking at asking the neighbor if we can't see in the backyard, ask the neighbor to do it. Well, the trouble with that is that is no longer a public nuisance. If it bothers your neighbor and nobody else, that's a private nuisance. Government has authority for public nuisances, not private. I don't like what we're headed. I think, it's so convoluted what's going on here. We ought to go completely different way. And it's similar to a point system that HUD uses. The HUD system, they have a scale, they write everything of importance as far as safety and health. They don't worry about if your vinyl siding doesn't match and make you paint to one complete color. We ought to go something different. We ought to go something called Inspire, which is the new version of HQS for safety and health. And if you score below a certain amount, then you get prosecuted. There's other things we want you to correct. Are they really important? Well, they rate things according to that point system. Everything's not rated equally. There's some things that are very serious that must be taken care of quickly. So you will score low real quickly, or you'll, in the case of Section 8, you will, or public housing, you will lose that funding for it. This is more understandable. We've got good case law in it. And you know what? The training's probably cheaper too. I think we spent an average of $1,400–1,600 a person sending them to Dodge City this year. Training for Inspire isn't that. It can actually be done online. All right, I'm done for now.
Thank you. Anybody else have comments on standards, particularly?
My name's Steve Vogel. I'm the president of the Shawnee County Landlords Association. I'm going to ask Councilwoman Hiller for an exception. I don't have any comments on standards. I would like to, if I could briefly, I understood that this possibly could be a meeting that would talk about landlord licensing. Could I just have a few comments? I'll try to keep it brief, or if you want to shut me down, I can.
If you could wait, I mean, we've got 20 minutes left in the meeting time, and because the city leadership wants to move the code itself forward,
Okay.
we'll make time if it's even going to be an issue that moves forward. But yes, if
Okay.
you could let's see if we can get through the other things first, and then if
Okay.
we have time,
I
go
think
ahead.
I'm gonna hand this out, what I handed to you, I'm just gonna hand this out, but
Okay.
yeah, I'll yield.
Thank you, thank you.
There you
And we'll, again, if there's time,
go. Okay.
we'll do it. Anybody else have any comments? Thank you, Pat, on those, on particular standards that we're requiring, that we either need to add or that are a little too stringent.
Hi, Danielle Twinlow, Community Advocate. I just want to reiterate that working on the Community Health Improvement Plan, which comes from researching the issues within our community, within the county every few years, as well as getting feedback from our community about needs. Housing and community safety was something that came up for the first time. And will be a part of the Community Health Improvement Plan. And part of writing those goals, I do want to reiterate that INSPIRE was a looked at standard that was researched heavily within the committee. The finalization of what those recommendations through that CHIP will be given here shortly. By the end of this year, we'll have the 26 to 29 recommendations, but I will state just preliminarily that INSPIRE was heavily researched as standards that many committee members in the housing realm across our community have looked at in depth over an extended period of time, not just pulled out of nowhere. So not sure if the actual naming of INSPIRE will make it into the final document, but was discussed pretty heavily and looked at as a pretty good standard. I believe HUD is the place that utilizes that standard in that system. And so that is a very much of a good starting point. And I'll wait for more.
So your thoughts, your exploration was on INSPIRE, not particularly on our code, and it was favorable.
So there were,
Because syncing up the HUD standards and our standards, it used to be, because I've looked at it before as well, that, there's really, they reference the local housing code, and so it was kind of included in that way, and the only thing that what was then HQS required in addition to the code was a stair rail if there were 3 or more steps, even if there were only 3 steps, so they were very, it referred in the other way, and then a couple of additional
so a
things.
combination, right? So like the INSPIRE has that ranking system of like what are things that are issues that are actual public health and safety issues versus those other what are called more administrative, ranks and tiers them in a way for prioritization that really does make some sense. Many other cities that, and I can come back and reiterate on that registry, is that is one way of being able to prioritize some of those things with that kind of standard, right? However, the Kansas Housing Advocacy Network, their legislative priorities for this year will be to advocate for that international code to be a state standard.
Oh,
They're
really?
actually going to
Okay.
recommend the 2012 version, I believe, even though there's a current 24 version, but that the state standard be the 2012 version, and that cities can then also obviously implement additional code that makes sense for their community, but that to at least have a base level. So the Kansas Housing Advocacy Network will be, that's part of their 26 legislative priorities that they will be moving forward with in the 26 legislative cycle. So we did look through all of that as well. It was heavily studied and a partnership and pairing of the two, there are pieces that make sense within both. So not sure if in the final document either will be specifically named, but more so that those both have the standards in them that were heavily researched and looked at, particularly with that tiered system.
If I can ask you a question here. Home rule has been a real high priority for the city of Topeka, and right now, the State Residential Landlord-Tenant Act and the Mobile Home Landlord-Tenant Act all refer to the local ordinance. So your coalition is wanting the state to supersede us and take over minimum standards?
Oh, we don't, like, I'm not a part of the Kansas Housing Coalition. That's
Okay.
a statewide coalition.
All right, either way.
And so they are looking at even, I mean, there's like 4 pages of recommendations, and part of it is to strengthen up the Kansas and Landlord Tenant Act and some language within that. So it's not just one piece, they have multiple, which includes some language that allows local municipalities to have other stronger approaches, such as what inspections might look like, or requiring the registry. But the registry, and again, I can come, refer to that a little bit later, doesn't have to look like the way it's necessarily being said. Many other communities start off with pilots using data of what is the most problematic. Our community, the most problematic is not the small mom and pop or local landlords, that it's corporations. And many other cities start with that registry and that code enforcement, starting with a program that is looking at those corporation, multifamily unit type of registries, and strengthening up that LLC. So part of the housing corporation will also be advocating for like that local LLC to make sure that if you don't live locally, that there is some accountability with your resident agent or some other person. Lawrence has that standard as well as several other cities throughout Kansas. So some of that legislative priority is going to be giving or requesting that there be more strengthening language within that Kansas and Landlord Tenant Act. So,
Okay.
yeah. And there was a lot, I will say that when Kansas Legal Services did their information night, they did break down what is superseded versus local and state, and what does count and doesn't count. And I believe that was a very valuable informational evening. And it'll be interesting to see how that might change if any of these that the tenant law changes with it. So I do want to wanted to reiterate that those standards that are coming out about our local, that those agencies and organizations in the housing realm that research that did find some value in looking at those tiered systems, but also with that code. So
So the tiered system of Inspire, you all researched and liked as well, and scoring, that's good to know. Any particular standards that
it's very robust. There are
and I'm talking about what we have now. We have the 2012.
Right.
It updates to the 2024, which doesn't drop anything. It just added or clarifies some things.
there
And again,
is-
we grabbed the pest control that somehow didn't make it into the 2015 vote, so.
Yeah, a lot of the discussion was going back to there's so much, right? Going to the roots of what we need to start with. Do we need to start with a registry and just having an idea, right? Do we need to start with, having this accessibility? So it was more base generalization of what the CHIP standards are of moving forward, but not necessarily full on specific code specifics.
So, because that, of course, is the fundamental, so we didn't want to overlook that in
Right.
our work here, because all of the procedures, all the fines and fees, all that are based on whether what we are asking people to do
Correct.
is reasonable.
So part of that registry of what was looked at as well, right, is that tiered pilot system wouldn't be a blanket thing. It's just not possible in a city our size to be able to address it in an effective way anyways. And so the tiered system that many places start with of just what is the data showing? The multifamily units, the code violations, we have, one corporation who owns now 88% of all multifamily units, and looking at just one of his units within about 17-month period of time, over 130 cases within court of evictions and other things in one of the units, right? And we know statistically that those corporations are about 3.7 times more likely to have evictions than the mom and pop landlords. And really the way that these fines and fees structures that work in other places in this kind of scenario is you then have time for everyone, for educating mom and pop, holding, code like it's already been done, right? You have the coffee with code, but also offering classes that, if landlords attend these and get services and get information, or even have, right, using some of the incentives that we have that can be used. Wichita's using LIHTC, and there's ways to do RHIDs where we can make areas for landlords to rehabilitate or to do upgrades and get incentives for those properties that need that. And that by doing so, by participating, we can incentivize them for that. And they don't have registry fees, right? But there's ways to tier that and prep so that these fines, fees, and code can be rolled out in a way that's equitable, but also addressing our highest need, which is these corporations.
Well, and thank you for that. I'm going to ask and see if others have standards to talk about. Again, the issue of the whole changing our culture of property maintenance initiative and what we need to do overall. Hopefully your group, as well as any others, are evaluating or are, again, we needed the update that we did yesterday and the conversation today, what we're doing already, and not starting from scratch, but looking at whether there really are gaps. There are different ways to approach things. Particularly our police-fire partnership is a pretty exciting and basically no-cost approach to making contact and observing and being connected with all of the multifamily units, which we did too identify as at least a current challenge. It hasn't always been, but it sure has been lately. And so, any other comments about the content, the standards that we have? I will tell you that I've raised a couple, and we're double checking them. One is the issue of the definition of rubbish and what all's being taken. We've had some complaints about people who had their whole property cleared. John has done some clarifying on that it's not just any particular item. They've added some language. You can see that in the draft. We've got people who are kind of junkers who are collecting old appliances, bicycle parts. Is that bad or is it okay? We've done some fine tuning about the fact that if it's lawn furniture and it's intended to be there, maybe they shouldn't be taking it. But if it's sitting, or if it's a plastic tubs, which have been taken before, but now if they're closed and the stuff inside is dry and they're not wet and not gathering water and causing insect infestations and so on, maybe it's okay. So some things like that, but double checking that we're not taking things of value from people unnecessarily. The other issue, and I challenged him one-on-one about some of the things that they've taken, is his refresher was that the key word in there, again, back to you talking about words, you're right, is the accumulation of, not that there's one or two things. That many of us as homeowners might have one or two things in our backyard because we like old broken down wooden furniture or whatever it might be. We think it looks country classic or whatever. So thinking about those, the other was we were going to take a look at the occupancy description, which is very, very hard to read and is limited to bedrooms, living rooms, and dining rooms, which is not necessarily how people structure their homes these days. Have we made any progress on that one yet?
I'm going to research what planning in I think it's Development Services has for the occupancy rules.
Okay.
I think Commander Stewart on building code too.
Well,
We're going to try to match that.
You can also look at our prior property maintenance code. So rather than saying how many people per bedroom or whether you can walk through a bathroom and things like that, it just said it defines habitable rooms as versus non-habitable. Non-habitable meaning bathrooms and kitchens where you're not going to sleep, and hopefully, and so they don't get counted, but otherwise you count the square footage of the habitable rooms that are code compliant. So not the basement either, unless it's
Right.
finished and has fire exits and stuff like that. And you look at just a gross number of people per unit and don't have to get involved in where the bed is and who's sleeping with who.
Right.
So those were two that have come up in our internal discussions. We really, again, working hard to interpret standards in a reasonable way, enforce all of them. The idea is if code comes out, they're going to inspect on the whole thing, not just what you called about or what somebody else turned you in for. And so we want to make sure that it's fair and reasonable to have it. I don't know how much time we have to look at the tiered thing, but that sounds very compelling. Pat mentioned it, but didn't have time to describe it the other day, and it sounds like Danielle's group has looked at that as well. Anything else on procedures? John has described at least what they're doing these days in terms of dual notice, if it's a rental property, reaching out, whether it's an LLC owner or a mom and pop owner or a homeowner, with the brochures that we have, the services that, consults that are available, the safety net for renters, for landlords, and for homeowners, so that we're not just throwing people out or under the bus, as they say. Anything else? Yes?
I just also wanted to clarify that there is not a differentiation between LLC and mom and pop. I think I would fall in the mom and pop category.
Probably.
I formed an LLC for tax purposes
Right.
and for the piercing the corporate veil.
Yeah.
But
The reason that got addressed was, and Kelly and John can address it a little bit more, my understanding, because that's been while we've been working on this, was that we had some LLCs that were simply not responding to their letters or their court summonses, and they said, oh, well, sorry, we just didn't get the mail. And so Kelly, if there's more to say, it was not so much to say LLCs are bad and everybody else is good, but we had some folks who were using that protective veil
Yeah. Yes,
in the wrong way.
We'd want to differentiate the LLCs from individual people, owners on properties, for that very reason, because if a person does not show up to their court date, a bench warrant gets issued. There is no legal authority to do that to an LLC. And so that's what implemented the LLC ordinance on default judgment. Made a huge difference. Our good actors show up to court. And, but we didn't have any mechanism for the LLCs that were just ignoring it entirely, knowing there was nothing to be done. And so that's what prompted that.
I just didn't want anyone to think that if it's owned by an LLC, it must be a greedy corporation.
You're right.
Sure.
That's just for my tax form.
That's good.
So,
Yeah,
It's
no,
important. Meanwhile, in terms of the discussions of registry on and off, it's, with Google and various sort functions, it's pretty easy to figure out, if needed, where you've got the same individuals with multiple LLCs. Again, investigation only gets done if there's bad actors, but it's possible to figure it out. And again, try and provide the service the way we intended to. Means you got to connect with people first. So, if I defend that. Anything else about the fines and fees? Again, we've talked about it quite a bit, and it is a little complex with the admin side and the criminal side. Anything else about that? Okay. Well, it's 11 o'clock. There's two of us here on the committee. Councilman, do you have any other questions or comments?
Just a comment that we've gone through a lot of information today, and like on other committees, we've talked about verbiage in a lot of ways. And I think that sometimes when we have our meetings and we have public people listening that do not have the information that we have, how confusing this can really get. So my only comment is that I think that we need to really think about how much we dole out to the public in these meetings, because as he was saying, even something as simple as mom and pop and LLCs, a lot of people don't really grasp what that means. And when we have a committee, a meeting as important as this one is for changes, we need to really think about verbiage. Thank you, Chair.
Thank you. You know, what's been interesting to me through this year is that with all of the conversations, it seems like the fundamental code itself has been okay. And, you know, I brought up a couple of things. Again, we on the council are the ones that hear it when it doesn't, when it hits the fan and it isn't working. So, you know, trying to make sure that we've got our words right. I guess we're not, so we still want to, as soon as, I don't want to recommend the code prematurely. On the other hand, we want to get that moving so that we can concentrate on these issues of whether we need a registry, fine tuning any of the procedures. Those can happen with the agreement on the code itself in place. And so if we can get that out of the way so that we can then focus on, okay, what's the whole array of what we wanted to do? What's already happening? What are there gaps? And if so, how do we address those? If we could start doing that in our December meeting, it would be great. I'm just not sure. What's the sense on the part of anybody who's here? Again, we probably got a total of 30, at least, letters or calls or people that came and testified, particularly prompted by what happened on the 12th of November, which got people's attention, which is good. What's the sense on whether there's more out there that we need to learn or whether we should move the code? Steve?
I'll try to be brief. It strains credibility, and I'm talking about enforcement of the code, that there are some landlords that have gotten by for years, and I'm talking about years of blatant violations. And to my knowledge, nothing has been done. And I would like to know, first, is that true, that nothing has been done? Are some of these serial violators, have they been fined? Do they pay their fines? How is that being enforced? It's just not credible to me that the ordinance is already on the books that has graduated increasing fines and possible jail time. Has that been done? If not, why has it not been done?
So I can answer the actual enforcement if you want to do the prosecution part on it. Anytime, and Steve, I think we spoke about this many times, anytime that we get a call, especially when it involves an interior violation, let's say a rental property, my inspectors will go out, will inspect it, take photographs, interview the occupant, find out how long they've been there. And the number one issue that I make sure that my inspectors ask is that, have you spoke to the landlord yet about this? Have you reported this? And if they said yes, then we're going to make a phone call to confirm it, right? And we're going to file the paperwork. Then we're going to give due process time to make the repairs. Now, the repeated offenders that you're talking about that somehow always end up in court, we don't actually flag those or anything, but we do note that this is the third time we've been at this complex. Maybe it's not the same reason, maybe it's something different, but it's still the same complex, right? So we send those to prosecution. She's well aware of it. She has guidelines to go by, and if the property is repaired, if that specific violation is repaired before it actually goes to court, she knows about that too, and she takes that into consideration. So all this effort that we're putting toward the repeat violators, there's a reason, because we don't care anything. I don't care anything about the owner. I care about the occupants. So if I can get the problem fixed so they're not suffering, that's a win-win for me. I know that the owner is benefiting from that because he doesn't have to show up to court then if I can get the problem fixed. So that doesn't just apply to one person, that's going to apply to everybody. So if I can make phone calls, if I can get Pat on the phone and say, Pat, what's your update with the case, or any other landlord? My goal is to keep you out of court, right? And to protect your occupants. So get it repaired, get it fixed. Now, let's just say I can't, and it ends up in court, and Kelly can answer for the rest.
So we do use the tiered system for the fines, and those are only on convictions. Pretty typically, that's either going to be with habitual violator or repeat offenders, such as the large sanitation issues when we had multiple cases all across town. We do use the tiered system. We use the tiered system with certain like large apartment complex issues. And we use the tiered system whenever there's default judgments. And really, that's probably where it comes into play the most, is on the default judgments, because those are cases that the owners are not participating in the process. They're not doing anything to address the violations. They're not showing up to court. They're not talking to property maintenance. No progress is being made whatsoever. And that's usually where the tiered system comes in. Now, I particularly have never requested jail time for any code violation. It is on the table as an option because that's what's in the code, but no, it's really been about using that tiered system for counting up the convictions. And those convictions on the tiered system are limited to 3 years. So we only look back 3 years.
Can you answer the question, do some of these owners pay their fines?
Oh, yeah.
Oh, yes, they do.
They do?
Well, the attorneys pay it, Steve.
Okay.
They don't pay it.
Well, okay, I'll
One of
say
our
that, I
top
don't want to take up
offenders
too much
is
time.
pretty
Yeah.
much up to date with fines and fees, so he, or she, I guess, without being specific, one of our top offenders has had quite a few write-ups, will pay their fines and are up to date, most of which are voluntary compliance eventually.
Okay, well, I guess I'll make the comment. As a practical matter, it seems to my observation that whatever you're doing is not working, because the same violators keep with the same offenses time after time after time for year after year after year.
There is the struggle because with an individual who uses an LLC and multiple LLCs, upon conviction, that LLC counts as an individual. I can't tie it back, she can't tie it back to the actual person. So that LLC would have to be convicted within 3 years under that same LLC. So it does, it is a little bit more difficult, and we've looked all the way up into the state level to see if there's any way that we can tie those LLCs back to that individual legally, and we can't. It has to be at the LLC level, and so there is that kind of a little bit of a loophole. I don't know if you would call it that, but it is unfortunate that it has to be at that level. We can't necessarily tie it back to the individual.
Yeah. So it just sounds to me like basically what you're saying, nothing can be done.
It can, but it definitely, that pool is a little bit smaller than it would be if we were to cast that net just based on the actual individual rather than at an LLC level.
Because I know, I actually looked up one of the worst violators, and I was looking under a particular LLC, and I found out with some help, no, they changed their LLC, okay? So now that just starts the
Well,
clock
that was
all over
created
again.
with the best of intentions, right? But it's been a real challenge for us in code compliance.
Yeah, I don't know. Okay, well, I think I've made my point. I just,
Yeah.
I haven't seen anything here that makes me think that this is gonna get any better. I'm sorry. But I hope you can prove me wrong. I really do. Thank you.
Thank you, Steve.
Thanks, Steve.
Can I reiterate that? So there are cities within Kansas even who have established through that, licensing procedure, the ownership disclosure and related entity accountability. So implementing into the ordinance, which models a disclosure of beneficial ownership in accordance with federal FinCEN beneficial ownership rules. So one of the local tenant groups has spent the last year and a half actually pulling all of these FinCEN documents for these multifamily housing units and the violations and their Fannie Mae report, like all of it. So Lawrence has something pretty similar that part of that having to have someone with that LLC that's within that boundary limitation of the city. When they register, it connects the dots by doing that. And so having that license then connects them to all those other different LLCs because that beneficiary has to be noted. And so that's part of how they've begun. Like none of these things have been in place long enough to get a lot moving because you obviously have to build it, but several places, in the ones out of state who have had these going, I have references of how they've been working, but there is a specific way within that ordinance, and there are standards, at least at a federal level, that kind of allow for that language to be added in to start connecting those dots. But it starts with kind of like that licensure or registry of those units and having that beneficiary noted within boundaries of like, I don't know, I think Lawrence's is within like 40 miles of the city.
Well, and the deal is here, we've already done that too. And so with technology and sorting and so on, Nicole has done all that. I mean, we know who those people are. We know who their contact people are. You still run into the situation of the people that are not going to respond, and that ends up being arguably the same people. And so the issue is if we already have the capacity to research and what is the value of the extra step?
Well,
and unless
but
there's a way
I
to
think
change
that's
the
the
law
legal part
about
of it.
LLCs,
Right.
then no matter how much work you've done making your list, it doesn't change your legal options for.
Unless you write the ordinance, right? Unless you have the
apparently-
registry. So you can look up those LLCs and research them all you want and find out resident agents and which LLC owns which LLC. But unless you have it written in ordinance that there's accountability, like specific language that resident agent has, and there's like sample language of like, you know, the violation issued to one entity shall constitute notice of violation to all related entities and repeated offenses under blah, 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 right? Like there's ways to put within that. If we don't have the language that those related parties are responsible then to connecting all of those together, we can look them up, but unless we have that ordinance in place that states they're liable.
I think our legal staff felt like,
And I
that we
think,
couldn't do that.
I think the difference is that, and that is also linked to registries, and that's what we don't have.
Right.
And that's
But
what.
As our current system right now, we
Yes.
can't connect those dots. Even if
Right.
we were to do the research on the legal side, we cannot charge them based on
But there is a
Or
way to
research of
circumvent that.
connection.
There is a way, and it really goes back to that rental registration and getting that into part of the system because then you can link them together if you do it within the registry and the licensing with the rental registration. But of course, that's really tabled at this, at the moment.
Yeah.
And so, but that is one step in the process that would get us there. But as it is right now, we just have to follow Kansas law, which is each individual entity is its own individual person.
But there is a way to circumvent that.
And that would be going through the rental registration where the LLCs are disclosing ownerships. And so.
Licensing as a business to have this property. And again, like you can tier that system where it's not a blanket, that every person who has a rental property, you can tailor it to multifamily units or, as others have done based on whatever the city situation is, and start with a pilot that way. While this individual has maybe just a handful of individual houses.
Well, as
But-
you all work on that, maybe acknowledging the fact that your group as well as the city staff have already done the gathering of the data. And I
Yeah.
say that because no one has ever put a price tag with that.
So
And
it should pay, I mean, most of the time it will pay for itself.
Well, but there has to be, that's been an overwhelming part of what the communication has been. And so, how much the fees would be, whether they'd be passed on to tenants, backing into whether it's necessary at all if we already have all the information we need. And it sounds like we have all the information that we need, but if somehow that allows something, again, we need to make sure that even if the connection between the LLCs, if that's something it can do, whether that's something we need or whether we're already getting what we need. And if we're not, that's what came out of this discussion 2 weeks ago was, okay, if we already have the list, if we can't bar any X or Y landlord or LLC from doing business in Kansas or in Topeka, which is what a lot of people hoped and they thought that something like that would do, then, kind of filtering through what people were hoping for and what really can be done, and then filtering through what we already have and whether we're really missing anything. And if so, what is that? What's the fix? And what would it take in terms of time and expense to do it would really make a difference in having a good conversation.
And I
about
think it can, back to Mr. Vogel's point, there hasn't been enough of the protections in place here in Kansas long enough to see the benefits, because of course it's a phased process. You have to build the cases and then you have to, the process. But in other states that have had to implement this, in similar size communities like ours for the same thing, right? Corporations coming in, mass purchasing, then just kind of like not being here, right?
Well-
It has worked, and it has allowed for, the language to say after so many violations, you can't file for a license with us until X, Y, and Z has taken place, or your code compliance or your fees or all those things, and then you can't buy up another entire property until you're in good standing, right? So those
So
kinds
we've
of
been advised that was not possible.
But that's all to do with the licensing.
with the licensing and registration, like that program has to exist in order to build and establish that ability to put those limitations on.
Okay,
So, thanks.
Thank you.
thank you. Because that's not the feedback that we were getting legally, so.
Can I speak? I respect
Yeah.
everyone's time. I'll be quick, but since the registry was brought up,
Yeah, go ahead.
first of all, I would ask for everyone to research the cities where rental licensing and the very thing that she's talking about has not worked out and has
We've been
exposed the
advised.
city to immense liability, getting programs reversed. One town in Illinois had a consent decree levied against them because of what they were doing and their daily fines for someone who was not in compliance with the registry. It was reversed, all the money was refunded, and then damages were actually awarded too. I think that was the worst one that I found. First of all, the rental registry, if there's going to be a fee associated with it, I hope everyone understands it will raise rent in Topeka. I don't absorb costs, just like when insurance and taxes go up, I have to do an annual increase in rent to cover those costs. Otherwise, in 3 years, why would I own real estate? Because I'm now losing money. It doesn't make sense. Any added fees trickle down. I might have to write the check on day one. It gets factored into rent. I don't know why anyone would implement something that has been proven to raise rent in a market. The way that the rental registry, at least what I read was worded, is that there has to be an interior inspection. You can't do it without a warrant. All the tenant has to say is, no thank you, you're not coming in. The code enforcement inspector cannot go in. I can't force the tenant to let the person in. And there's federal at least federal case law that I know of that you can't hold that against me. So you can't withhold a rental license from me because my tenant refuses entry. So if I buy a house occupied, which my wife and I do a lot, I can't go to that person and say, well, now I've got to get a license, so you're going to have to let the government come in. All they have to do is refuse. You can't withhold my license. There can't be anything. I also can't put in my lease where I require them to give consent to the government to enter their private residence. Also, I read in the licensing that apartment buildings would require one license, whereas every single family residence would require one. So why would I have to pay a fee of $50 or $250 per property when the worst offenders in the community have to pay one fee for the one building that they own that may have 30 or 50 units? So I think what's ironic about the rental registry, at least the way that it's written, is that the very people that are causing the issues in our community are going to be the ones that are least financially impacted, at least the way that it's written.
I think per unit was what was being explored, so that way then it would be, if you have 2 units, 2 houses, that it would be a $5, $6 per rental fee, whereas you have a multi, 100 units, then obviously that's gonna be much more substantial.
Good points.
Yep. I can share a case law where cities were exposed to liability for the very wording that I was reading. Judges struck the ordinances down. They refunded money. They didn't work out. I also couldn't find a single instance where a rental registry actually made things better as far as what does it cost to rent a home there and the actual conditions over a period of time. I could not find one study that said this is why you should do it. I understand there's anecdotals about other jurisdictions that have done it, but I keep hearing that they haven't done it long enough, or well, that one wasn't exactly how it should have been implemented, so that's why that one didn't work. Not one success story. So those were just the points I wanted to bring up about the registry.
Thank you so much.
Thanks.
One more, and then I will do my best to wrap this up.
Okay, I'll try to be brief. I'd like to know this, I handed this out to everybody, and the question number 1 says the ordinance states the city has the power to deny, revoke, or suspend a landlord license, and what are the circumstances that would cause the city to take such an action? Let's just say that you found the silver bullet. We're just gonna deny this person a license, and that will get them out of here. Is that gonna be like the dog that caught the car? Because, then what will happen? If you take this through to its logical conclusion, I'd like to know what's gonna happen. This will make Timberley Apartments relocation of tenants look like a drop in the bucket.
Question for you, because this,
Yeah.
all this kind of, I've gotten all this kind of feedback that other cities in Kansas have them, but all they're doing is it's just paperwork. It's just getting registered once a year, and there's nothing else that's happening. The issue that just got talked about of a registry linking and giving more power, if you will, to influence what happens with a certain property owner. There seemed to be an expectation or understanding on the part of some folks that the license went with the person instead of with the property. What I was told was that rather than there was an example of the driver's license. You have one infraction, you get a warning, you have another infraction, you get fined, you have another infraction, and you lose your license and you can't drive anymore. And the advice that I got back was no, that's not the case, that any rental licensing is a certificate, just like a code compliance case, on that particular property at that moment, that it complies with. And it's not the landlord at all, it's the property that is getting registered or getting licensed, if you will. And so the dream that some folks have had, that would somehow put a landlord out, a really egregious violator out of business, was not practical, that it would still be property by property and circumstance by circumstance. Can you?
I can sort of answer that. I am not the lead on this particular ordinance. I've been in the meetings and I kind of understand it a little bit, but I'm not the one driving the bus on this particular project. But it's my understanding it does go to the property and not to the individual, as it is right now. I think there's a lot of things being talked about. There's a lot of things on the table that are being discussed. I think this rental registry, first, we brought it to council just to see if there was any interest in it whatsoever to continue down the path of perfecting this project. It's in its infancy. we just really wanted guidance on whether we were wasting our time and even looking at this. And so that's really, I think, what the purpose of raising this issue to council in the first place was, is there any interest in going forward and researching the correct way to do it and how it would work for our community? And so there may be a lot of issues that people are bringing up to the table that they don't like about the registry as it is in its infant form. But I can't stress enough that it is in its infant form, and there are a lot of things that we do need to address and that we do need to look at to see how it's going to actually make a positive impact and what we need to do.
Displacement would be a huge issue.
Yes.
You know, if it
I
really
don't
were
think
to
we
go
would go
through.
after displacement. I think we would suspend the license if we need to, for whatever reasons. Let's just say this one LLC has 6 cases in court unresolved and their life and safety related. So that sounds like a good reason to suspend their license. So every day their license is suspended is a $100 fine, $200 fine, $300 fine, whatever we decide, right? So that's applied to them. So it would be in their best interest to make those repairs, make contact with court, get everything straightened out, and get their license reinstated. We're not after displacing people at all. We care about them more than anybody else. And that's why we're trying to hold those certain folks accountable.
So it'd just be a monetary fine, but this is the point I've been trying to make all along. You've already got that on the books.
Well, we're talking about licensing.
I know.
Yeah.
I know,
But
but you've
either way,
already
what-
got graduated fines on the books with code enforcement. That's what I don't
So
know.
the question really is, what's the problem? And what are we already doing? What are the facts of, problems out there, whatever it might be? What are we already doing along those lines to make sure we're not overlooking steps, researching and coming up with lists, already having fines? What do we already have? And once we've inventoried that, what are we still missing? And would this particular proposal solve to that? And again, then talking about displacement and so on, talking about cost. But first, really going fact-based on what's the issue.
Yeah, well, I can tell you, when I spoke at the October 12th meeting, that was one of the last things I said. If you enact licensing with going with what you're saying, the landlord will be just violating 2 ordinances instead of just 1. What's the point?
If
Why are
we
you
could
going to all
connect
this
those,
trouble to do
yeah,
this?
if it really is possible
if
to
you've already
connect.
got it on the books?
On that note, we're
Okay.
now.
Okay, thank you.
Thank you so much. As chair of the committee, I will consult with senior management about where we go. This has been some good discussion. We've got the potential to invite all those other folks that had comments earlier to come in. We'll see what they want to do. I'm not sure. I personally feel like we're ready to move this forward to the whole council, but I understand the time as well. Eager to see us spend as much time as it takes to pick apart where we are, all those facts that we just talked about. Where are we? What's still missing? Is there a way to fix that? And do we already have that, or is there something new that we need? This has been, thanks for going ahead and raising some of those issues that got them out on the table anyway. And Councilman, anything else to?
Not for me. Thank you,
Okay.
Chair.
I'm, unless you're inclined to, I'm not inclined to ask even for any preliminary vote from the 2 of us at this point, but instead to move forward. We'll do the best we can. We are going into the holidays, but we can pivot and see what we're doing. I know that one of our committee members is out till the 2nd of December, so we could still do maybe a public hearing or schedule something in early December if it seems like there's people who would participate and we could learn from that. So see what we can do. Thank you, everyone, for coming. We are adjourned.
Thank you.
John,
Sir?
I have a quick question.